All right, so that's what we're focusing on now, and we've got two gentlemen here with us. We've got Kenneth Odedika, who is a legal practitioner, as well as Curtis Adigba, also a legal practitioner. Gentlemen, thank you for coming on this morning.
Thank you for having us.
This matter, is it an issue for you? What kind of issue, for instance?
Well, it's an issue. It's a major issue, not just an issue. It's a major issue. We're talking about the Chief Justice of Nigeria, and that's the head of an arm of government. So if you're charging him or arraigning him for some unlawful or illegal act, it's a major issue. So I don't know if you want me to go into it right away.
No, please go ahead.
Good. Now, when I read of it, I thought it was one of the fake news. I mean, we usually have fake news in Nigeria because I read the federal government asked the CJN to resign, and then saw the reason they gave.
The petition?
The petition written, and then the CCB acting fast, and CCT now fixing a date for arraignment the very next Monday. I had issues with it, and I still have issues with it.
So what is the issue for you?
The issue for me is that what the CJN is accused of, there are actually 2 or 3 aspects of it. What the CJN is accused of is something that ought to actually have gone to NJC. And that is clear from the decision of the Nkanjiwa case. Now, they went further to say that CJN had actually replied, and according to them, indicted himself. The act setting up the law is very clear on this. If the CJN actually replied them and said and admitted, somewhere that what they are saying is correct, to the extent that he omitted something in his form, the law says automatically that extinguishes the rights of CCB to go to now refer the matter to CCT. That is the position of the law. I think it's 3D or so, where it says that where the person being accused of defaulting admits in writing, and that's what we read. I don't know. I mean, I'm not part of any team either for the prosecution or the defense, but that's what we read. So if that's the case, that means this thing also have gotten to the CCT. That's the second time. I had always talked about the fact that they should have gone to NJC. And the argument that, the man has NJC, in effect, we can't even sue him if he takes somebody's land, because the case will eventually get to the Supreme Court.
Okay, so what is the issue for you, Mr. Adigba?
Okay, let me first of all start by saying it is a consequential issue, because you have a head of an arm, an important time like the judiciary, being arraigned. But it's not a strange development. This is because we live in a country where the real situation should be nobody should be above the law, no matter how highly placed. Nobody is above the law, nobody is below the law. We're all under the law. And so for me, all the argument about the timing and how high he is in government is not even the issue for me. What then is the issue? Look, we have a CJN who superintends the entire judiciary in the country, a very, very important position. He knows the law. He should have declared his asset. He didn't do it, okay? And when you look at what has happened so far, let me give you a background. First and foremost, people are interpreting the role of the NJC as a super court. That's not the intention of the Constitution. When you look at the Constitution, section 153, the NJC is just one of the bodies established by that Constitution.
Did they say it's a super court in that manner, or they said that the matter must first get to the NJC?
That's why they are trying to make it a super court. Let me give you an example. The intention of the Constitution in establishing the NJC, like all the other bodies established by section 153, is purely an administrative thing. You know, you have a civil servant who works in an organization. He's been accused of misconduct. That body has got the power to intervene by investigating, okay? It can discipline to some extent, but once the issue is a criminal matter, it does not have that power. Now, you hear people refer to...
The NGC doesn't have power to look into this particular matter.
Yes, it shouldn't.
Okay, you categorize this as a criminal matter.
Yes, and because it's a breach of extant laws, which is criminal in nature. Now, here is the point. We are all talking about the case of Ajia Nganjiwa and Federal Republic of Nigeria, which is the case where the Court of Appeal held that a judicial officer accused of misconduct should go and be tried by NJC first, found guilty, and the judicial cloak taken away before he can be charged to any court in Nigeria. All right? That was the decision of that court. That decision has been appealed. The appeal is pending before the Supreme Court. But then, we've taken it, out of context.
So on the strength of that scenario now, are they wrong when they say that, look, insofar as there isn't any contrary decision?
They are wrong, and I'm going to prove to you. In the case of Ganifa Remi against the federal government of Nigeria, the Supreme Court said, even for executive officials, members of the executive that have immunity given to them by the Constitution by Section 308, even while serving, can be investigated. Okay? They can be investigated by court and by the security agency. What you cannot do is to put them on trial while they are still in their office.
Quick one. There's something that I've been waiting for from the two of you. What kind of breach or infraction do you want to? How do you want to categorize this one? The allegations against the CJN.
It's not criminal.
Is it something done in the course of duty as a judicial officer
or
as a public officer?
It's not. To me, it is something done.
Because my understanding...
I'm answering you.
Okay.
I got your question correct. I heard you right. First of all, it's not criminal. That's why there's no provision for somebody being sent to jail. And as was said in the same Nganjiwa case, as in Bukola Saraki's case, CCT is a quasi criminal jurisdiction. So in this particular case, it's not a criminal infraction. Now, on the issue of the second number,
is it a judicial?
Exactly. Now, that second one. See, if you are not a judge, for instance, as you are now, as I am, nobody's asking me to come and sending a asset declaration form to me. But if I'm made a judge today, and if I accept to be a judge today, that form will come to me, and I'll be bound to complete it by law. Right now, the reason...
Do you have to be a judge to be a public officer?
I'm giving an example. Okay. That's my own profession.
Okay.
I mean, it could be any other thing. Now, the reason Onnoghen was given that form to fill was because he was a judge.
Okay.
If he was also maybe made a commissioner of industry, he will get that form. So it came to him, and in his own case, it came to him because he was a judge. So it's in the course of his appointment. It's in the course of his duty that he was bound to complete the form.
I think you are taking the provision of the law out of context, and I will explain why. All the arms of government enjoy some level of immunity. For the executive, you cannot prosecute them for criminal matters while they are in the office, like the president, the vice president, the governor, and the deputy governor. For National Assembly members, they have immunity for the things they say on the floor of the National Assembly. But they don't enjoy the general immunity from prosecution if they commit criminal offenses outside of the chamber. You understand what I'm saying? So that's why a senator can say to a colleague, I will impregnate you and nothing will happen. You cannot sue because this happened within the confines of the walls of the National Assembly. Now, for the judicial officers, a judge, while delivering a ruling, or saying certain things within his court, you cannot sue that judge. But the case of Nganjiwa is a dangerous precedent for this country because that's what that case tries to do is to overturn completely even superior judgments of the Supreme Court. The case of Garba and University of Maiduguri, the Supreme Court laid the principle clearly that, look, an administrative body can look into misconduct, but it cannot try criminal matters.
So
what they have done...
The point I think he's making is, or correct it if it's wrong, and so pardon me for butting in, I think what he's saying is that the CJN is a judicial officer, is a public officer serving in judicial capacity. Mm-hmm. Isn't that the case? And as such...
Yes, but he has no immunity.
No,
now, what they are saying, look, the
is
problem
it about
here,
the immunity
let me
or
tell you,
about the process of trying him?
What is the law today?
Let me tell you what the
stated by the Court of Appeal until if the Supreme Court overturns it.
Is that the case or not?
Look, I just consider that there was a decision of the Court of Appeal, and with due respect, there are some of us who disagree with that judgment.
But it's still the law.
And the reason is for the simple reason that they are trying to grant immunity to judicial officers.
My apologies, but whether you disagree with the judgment, you have a right to disagree,
Absolutely.
but it is still the law. Has it been set aside?
No, it has not been set aside.
So your disagreement falls flat on the face of that, doesn't it?
Yes, but look, let me make a point. Even when the Supreme Court is sitting or the Court of Appeal, there can be a dissenting judgment. And it can also, the principle in the dissenting judgment can also become very useful
Okay,
in the
maybe
future.
we should do
so
this.
That's the point I'm making.
Let's do this. For instance, now that when the case came up,
Yes.
the bone of contention for a lot of lawyers, for instance, for two of you too,
Yes.
now is the procedure. Where is the case supposed to have gone to? Is it NJC first, or are they right to have gone straight to the CCT? And what points of law do we support that with?
Okay. If you look at the Constitution that establishes the Code of Conduct Tribunal and the NJC, the third schedule of the Constitution, Part 1, Paragraph A, says the Code of Conduct Tribunal can receive, the Code of Conduct can receive complaints from the public about a public officer who is in breach of anything. And it can do that and go ahead, refer that matter to the Code of Conduct Tribunal for trial. And I'll tell you something.
Public as well as a judicial
Yes.
officer?
Yes.